Welcome to the Secrets of Personal Injury Law with Colin Bober.
Hello and welcome to the Secrets of Personal Injury Law with Colin Bober. Colin is a personal injury attorney who has represented over 4,000 clients with a gross settlement recovery of over $50 million. I am your host, Kevin Rosenquist, and today's episode is called Dollars and Cents: How Economic Damages Are Calculated in Injury Cases. Colin, great to see you again.
Happy to be back, Kevin.
Yeah, I'm happy to be back too. You gave me a little grief because I wasn't at the last few episodes, but I'm back.
Happy to see you.
Happy to see you as well. So tell me, what are some of the biggest misconceptions people have about the value of their claims?
Well, at the outset, it's kind of difficult because everybody's been through a lot. There's a lot of trauma, especially given the circumstances of the accident, whether it's a DUI, DWI, or anything like that. In general, it is a traumatic event. It doesn't matter if it was severe or light. It doesn't matter. And most people, their first thought goes, so how much am I going to get for pain and suffering? Mm-hmm. Pain and suffering is an aspect of the claim, but the burden of proof is on the plaintiff, the person pursuing the claim. So if you don't have any medical bills to produce in terms of any treatment, whether you went to the hospital, maybe you went to your PCP, maybe you got some chiro, whatever it was, if you don't have something to actually show an adjuster or an attorney on the other side or in a jury, it's very hard for them to come up with a number to give you that's going to make you feel like it's enough to indemnify their defendant forever or make you whole. So you have to prove something. And that's the hard part, is at the beginning, people will always want to ask, how much am I going to get? And I can't answer that in good faith because I don't have anything to look at.
And those are considered non-economic damages, right? Like pain and suffering?
Correct.
What else falls under that category of non-economic damages? And what evidence do you need to prove them? Because that definitely seems like it'd be tricky.
Well, there's pain and suffering, which is the one everybody understands, and that's kind of illustrated by how much medical treatment you have to endure. If you have to get chiropractic and it's painful, or if you go through physical therapy and it's painful because you have stiffness or anything like that, or you have to go through injections where you have to go under anesthesia to do the injection to decrease inflammation. Those are procedures or modalities that would create pain and suffering. There's also the aspect of mental anguish. Well, did I get hit by a drunk driver? Sure did. Well, now I have nightmares. Now I can't focus at work. Now I have PTSD and I don't want to be in a car at all. Those are the aspects that help illustrate those damages. And sometimes you need counseling or therapy to be able to work through those.
It's got to be very difficult to prove that for economic damages, though. How do you, as the attorney, how do you approach that as a general rule?
Are you asking about economic damages?
No, I'm still talking about the non-economics, just only because, I understand what you mean. This person can't get into a car anymore. They're hit by a drunk driver, so they're having nightmares. But I mean, do you have to prove this kind of stuff? Obviously, the other side is gonna fight it. So I'm just curious how difficult that is.
Well, there's a common sense aspect to it. I mean, if anybody gets hit by a drunk driver, and we as the attorneys say, let's try and settle this without a jury trial. Because laymen, or regular people on a jury are going to understand that getting hit by a drunk driver is traumatic. There is an exposure aspect to it from the insurance company side, because regular people, if we don't settle, are going to be deciding the verdict of this case.
Right.
So as long as it's testimony from the client, whether it comes verbally or in a written statement or in a recorded statement, that's how you would show those non-economic damages.
All right, so let's move on to economic damages then. How are those calculated? Is it pretty simple math, or is it more nuanced?
It's pretty simple math. I mean, at a fundamental level, you just start with the dollar figure of the medical bills. How much did it cost you to get to your, as close to pre-accident condition as possible? Was it the hospital bill? Was it physical therapy? Was it imaging? Was it pain management? What was it? How much did it cost? And then after that, once you have that dollar figure, you use those findings in those medical records to justify what you were talking about, the non-economic of how much did I have to endure, and cost-wise and pain and suffering-wise, to get back to my pre-accident condition. So, and economic damages are not just limited to medical bills, it's also lost wages. How much time did I lose from work? If my doctor gave me a doctor's note and said, I don't want you to lift anything above 10 pounds, but I work for Amazon, how does that work for me? Every case is different, which is why you have to look at all the aspects. So as long as you know how it's broken down in terms of economic and non-economic and identifying what those damages actually are, then it makes it a lot easier for the client to participate and help articulate what those damages should be.
You mentioned lost wages. I think we've talked about it before about future earnings as well. Like if you're unable to do the job that you were educated for or trained in because of the accident, because of an injury, how does that get calculated?
Well, there's a couple different ways you can just do it from a lost wages, like how much time did you miss, right? If you get paid by the hour, just do the math and produce your doctor's notes with your pay stubs and show that this is how much I would have made during that time period. And here's the doctor's note said that the doctor took me off of work based on medical necessity, therefore I need to be compensated. That's the easy way.
Right.
The hard way is the people that, we talked about it in a previous podcast where people are doing unique jobs. They're not the norm anymore. You have your Uber drivers, you have your Lyft drivers, you have your DoorDash people. I mean, they don't make a solid amount per week, per month. It's based on their work, how many rides they do or orders they process, right? So then you have to take their tax returns over the last 2 years and say, here's an average that they would have made during that time period, because it's subjective. And that's the only way you can get like an average or a basis to say with honesty and justification how much that person is due. And so there's so many, again, it's one of those fluid things. You have to take what you can get in terms of information and make the best argument you can based on the information that you have. So, and the other part too is if you're on the flip side where you're on a contract basis. Right. So I think you had mentioned that sometimes you're on a contract basis.
Well, yeah, I work for myself. So yeah.
Exactly. So if you have a contract that says, hey, I'm due to do this podcast with somebody, and you get in an accident and say, I can't do it. As long as you had that contract signed and negotiated and you lose out on it, then you're entitled to the reimbursement. So there are so many different aspects to prove it. It just depends on which bucket you're in.
Yeah. It seems that way. So can you explain punitive damages and when they might apply in a case?
Punitive damages, to be honest with you, I've never actually seen applied because there's some constitutionality to it to figure out if they're even applicable in certain cases. So basically, to get punitive damages, you would have to find somebody that is completely acting egregiously and without any regard to anybody. But again, when it comes to the car accidents and what we practice, the exposure 95% of the time is limited to the amount of the policy. Mm-hmm. So unless the insurance company completely just drops the ball and doesn't pay anything that's reasonable, and you go through a jury trial and get a verdict above the policy limit, and then the jury also determines that a reasonable insurer would have paid the policy limit and they didn't, that's the only instance that you're going to get for them to pay over the policy. So punitive damages in this particular situation don't really apply to these cases.
We've talked before about you and insurance companies. You guys always get along so well.
Yeah.
What tactics do they use to attempt to minimize damages, and what strategies are you able to counter with to help your clients?
Based on my experience, nearly 5,000 cases by now. I mean, I've heard a lot of BS. Okay. And most of it just lies in the fact that they just run these bills through a machine or a software and it just shoots out a number. But they don't actually look at the medical bills themselves. So all you have to do is get them to walk you through their evaluation. And if it's off from what you know is in the demand because you wrote it, then that gives you the best opportunity to negotiate because you're showing them that they're not negotiating in good faith. And if they're not, then you have no reason to settle with them at all. So they're the ones with the exposure because they have to protect their insured. And if they drop the ball on the 1 yard line, then so be it. We sue you and we go in court. And then you have to explain to your insured why they're getting sued. And it's because you're incompetent as an adjuster, simply because you don't want to read the demand.
Have you found that with AI because I've heard that insurance companies are using AI to help with certain aspects of at the beginning stages of these? Are you finding that's getting more prevalent where the offers you're getting are like, wait, that doesn't make sense. That's way too low.
Well, I don't know if it's AI per se. I know like certain insurance companies have specific software that just like takes the diagnosis codes and shoots out a number of what's reasonable and customary for the geographic area.
Okay.
No, so I don't know if they may have integrated AI, and I just don't know. Nevertheless, even if they did, it would be really gutsy for an insurance company to say, yeah, we evaluated this demand based on AI.
Yeah.
Right. I mean, I would love for them because that would be wonderful for me. If that's what they want to do, then that'd be great. But normally you can tell, because one thing you have to realize too, kind of going back to what you were saying, is that the offer for the medical bills is one thing. But if the offer is so low where it doesn't even cover, it doesn't even get anywhere near the medical bills or what the out-of-pocket expenses are, then the next question is, okay, so how much did you consider in general damages for, like I said, the pain and suffering? And if it's so low, then you don't need to negotiate because they didn't consider everything.
Right.
All they did was benchmark the bills for what they thought was reasonable and customary and slapped on some generals and said, here's your offer. Well, that's not incentivizing to settle. And you shouldn't put your client in that position to tell them to settle. So you know based on how the first offer comes in.
Is it sometimes difficult for you to convince people to go to trial? Because I know obviously most people just want it done with. And even if they're like, they get an offer, it's not the best, but it's okay. And the people are just like, I'll just take it. Do you sometimes go, I really think you should consider trial because I think you could do a lot better?
99% of the time, the case never goes to trial because the trial date is pushed out so far, right? So there are so many opportunities for the insurance company to settle before then that 99% of the time they do. You have to have a conversation with the client too and say, all right, here's where you are. Here's all the steps it's going to take in litigation. Even if it doesn't go to trial, there are several steps in between: depositions, mediation, hiring experts, and all that stuff that adds an out-of-pocket expense to the case. So if that doesn't benefit the client versus what they have now, it's kind of like a time value of money. Do you want the money now, or do you want to roll the dice later and potentially get the same amount? Because you may get additional money, yes. But because of the expenses you're going to incur to get there, you may end up in the exact same situation you are right now.
Right.
So if it's a terrible offer and there's no reason for you to accept it, I'm going to go, let's go balls to the wall. Let's go all the way because it's in your interest to do so. But it's also my job to tell them, here are the economics on what you have now and what you're going to have to pay to get where you want to go. What do you want to do? Here's my recommendation. And a good attorney should say, you should go or you should not go, and here's why. And the only thing you can do as a lawyer is give the client the advice because the ultimate decision is theirs.
Yeah, it's tricky because you're right. The ultimate decision is theirs, but you know because of your experience probably what's the better option. But sometimes I imagine it's hard to communicate that or at least get them to understand it.
Well, you're right in the sense that most people don't want to go.
Yeah.
One of the other aspects, obviously, you have to talk about the economics and the expense to go where they want to go, which can be astronomical, but.
Yeah.
You also have to say that you should take it if you're comfortable with it. The part you're trying to make clear is that once they settle, it's over. There's no going back. As long as they understand that the decision they're making solidifies the end of the claim, potentially, that's what you're trying to advise them and protect them from thinking, well, if I take this money now I can come back later. No, you can't, right? So that's the only duty or the only thing you're trying to protect somebody from is making that decision because they can't come back.
Yeah, you've talked about too. That's one of the dangers of accepting that early offer that the insurance company might give before you've even hired an attorney.
Just yesterday, we had one where an insurance company made an initial offer of like $10,000. We didn't have any of the bills yet. We just got in the case. They just said, well, based on what the accident looks like, we'll offer you like $10,700. Well, it turns out when we did order the records for the client, she's got $30,000 in a hospital bill. Do you want to take that offer? Probably not. But if she says, yep, I'll take it, then that's her right. But that's what they're trying to do is they're trying to get ahead of it, get them to settle. When they settle, it's over. And then they're saddled with bills they don't even know they have yet.
Right. Yeah. That's a good point too. Like, you don't know how long those medical bills are going to keep piling up.
Right. I mean, and that's just with the hospital. Because if you go to the hospital, it's not like you get the bill the next day.
Yeah, that's true. That's a very good point. Yeah. I've been in the hospital before and it takes a little time to get it. And you're like, what? I thought I was done with this, but then more keep popping up.
And they're divided in multiple parts. You have the facility bill, the ER physician bill, the x-ray bill, the ambulance bill. They'll keep coming, and that's why we don't recommend you get to take those first call offers because you don't know what the extent of your billing is going to be.
Absolutely. Yeah. You mentioned when people come to you, they like to say, what's my case worth? Because they're, like you said, they're emotional, upset, whatever. How do you kind of, reel them in a little bit? How do you get them to a place where they're like, where you can be like, all right, settle down. Let's talk about this and figure this out. Like, you kind of like part therapist.
Yeah, I mean, we've done these podcasts together for a little bit, Kevin. I'm pretty straightforward, and I'm just gonna say,
yes.
Yeah, I mean, I'm just gonna say I can't tell you that.
Yeah.
But the reason I can't tell you that are these factors. I don't know what your bills are going to be. Just like the girl with the insurance company, she got an offer pretty good on its face, but she's got a bunch of medical bills she doesn't even know about yet. So I can't answer your question for an incident like that, right? Because if you don't have your bills, you don't know what they are either.
Right.
And I don't know, maybe you feel good when you talk to me a couple days later, but then you find out you have a herniated disc and you have radiating pain down your arm that's going to require an injection. And after the injection doesn't work, maybe you need to have surgery to relieve the pressure on your spinal cord. I mean, that's how fast this thing can unravel. Right. And if it unravels like that, and then all of a sudden, by the way, you have to do all that, plus you're missing work, and you're a single mother with 3 kids with no car, how fast do you think we're going to settle if you need all that stuff to be taken care of, and you want a comfortable amount of money in pocket to convince or make it incentivizing for you to settle and release your claim for the rest of your life? That takes time.
Right.
There are a bunch of calculators online that'll show you potentially what you could get, but the problem is that nobody tells anybody ever that in Texas the minimum state coverage is $30,000. So if you get hit by somebody who only has $30,000 and you don't have any additional coverage on your policy, that's all you have, with the assumption that the insurance company, like I said before, doesn't blow it and doesn't do unethical things to get over the policy limit. But even that requires a jury trial 2+ years later. Right. So that's all you can tell a client. You just tell them how it works, and they have to make their own decisions based on what information I give.
Yeah.
It doesn't make any sense to try and estimate what somebody's going to get without the information in front of my face.
Yeah. Yeah. It's irresponsible for you to try to say anything because you'd just be guessing.
Right. And I personally don't want to promise something that I can't deliver.
Right. Absolutely. All right. Well, thank you for tuning into the Secrets of Personal Injury Law with Colin Bober. To connect with Colin and his team, visit boberlawfirm.com. And don't forget to like and subscribe to our channel. Colin, always great chatting with you. Thanks so much for your time.
Looking forward to the next one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.